American system of consequential damages, penal damages, and award costs to the winning party as per actuals. This will stop the unnecessary claims. You know that. This is a very, very important idea. And
what this book is suggesting is if that keeps increasing in terms of percentage terms, and more of us start beginning to lose confidence in the legal system, it's like that frog that will ultimately boil to death. So unless a whole host of us jump up and start screaming, that slow, gradual increase in lawlessness will cause a collapse of a nation.
Whose incentive is it today to get justice done tolerably quickly? Is it in the lawyer's interest? It is not. Is it in the judge's interest? It is not. It is in the interest of both plaintiff and accuser if they are innocent, but not if they are accused, if they are innocent, but not if they are guilty.
good evening to all of you. I have been a judge in different high courts, starting from Guwahati, Orissa, then Chief Justice of Chhattisgarh, then Madhya Pradesh, then Supreme Court. To ensure that criminal cases are disposed of fast in the trial court, civil cases are disposed of fast in the trial court, and I did succeed. Civil suits, what I did was increase the number of judges. And wherever there were excess judges in whichever district, I pulled them out and put them in right places where they were needed. The result was the system improved. So much so that the suits were being disposed of into 1 year time. Sessions trials were being over from the date of charge sheet in 6 months' time. So while the bail matter was pending in the High Court, the trial was over. While a temporary injunction matter was pending in the High Court, the suit was over. This was the situation in the Madhya Pradesh High Court. But then when I left, when I came to Supreme Court, I found all those had piled up in appeals before the High Court. The High Court was jammed. And strength of High Court judges had not been increased. So, when I read this book, I find a lot of truth in what he's saying. You reform in one side, and problems start on the other side. So criminal appeals got disposed of very late. They are all jammed. So this book, when I read, Mr. Anand Prasad has rightly titled it Unshackling the Elephant. Judicial system in India is really the elephant. It has to be unshackled. And he has raised these issues. Slow decay of the rule of law. You see that? Slowly taking place. I wonder whether you have read a book by Anita Gets Bail by the former Minister, Indian Minister, Arun Shourie. Read that book. He has given description, courtroom description. So, slow decay in the rule of law. Compliance with the law and the rules have become very costly. We're noticing that. And where is rightly mentioned is, so compliance with the law, if it has become very costly, it is easier and cheaper to circumvent the law. Therefore, no compliance. So people prefer to do that. No respect for contract. They commit breach and the relief is delayed. These days there are arbitration cases. In arbitration also, I have been doing arbitration since I have retired. I deliver my awards very fast. And therefore I get a lot of cases. But they all get stuck up in Section 34 before the High Court and thereafter the appeals. So relief is very related. Then no respect for laws, what is criminal law is concerned. And culprits go unpunished. He has mentioned 10% convictions only in criminal courts. That's right. And that is very much correct. But I must tell you, in Madhya Pradesh, when I was there, convictions are around 60%, 70%. right, in different trial courts. And bail is mentioned, not easily granted. This is the worst thing that's happened to our system. You rightly mentioned. He said bail is the rule, but now bail has become the exception. And trial itself, going through a trial and then ultimately being acquitted, is a punishment. You all remember that famous case in Noida, that couple, Talwar. I was in the Supreme Court when the matter came before me. After one of the judges retired, came for review. I said, why, when the CBI has given a closer report, why it has been opened up again by the trial court? And he summoned that was the challenge. When I was going through, I found a lot of gaps. And this was not a case where it would ended up in a conviction. Nevertheless, the law was, at that stage, summons can be issued from the magistrate if there are some materials. The court cannot go into that question. So we rejected the petition, but we granted bail. Eventually, what happened? The High Court included. Why they had to go through all that punishment, embarrassment, harassment, bad name in the media? Then he has also mentioned when the Constitution was made, the thought of will be being about, if you look at the preamble of the Constitution, socio-economic justice, all high-sounding words, almost like Ram Rajya, refer to Ram Rajya. What was promised to people is a Ram Rajya. Instead, it's failure to good law, deliver rule of law. Is the position. And then he says, people have become materialistic and want to accumulate wealth and have given up the traditional values. They become dishonest and greedy. A lot of problems are rising because of this character deterioration in our society. And when it comes to legal reforms, politicians or political rulers don't make that as a manifesto, election manifesto. They are not concerned with that. They'll rather pay some money to the people directly, 10,000 rupees or this, that, per month or something. It is not an important issue in election. That's what he says. But nevertheless, he has suggested some legal reforms. And some of the legal reforms I'll read out, but rest I'll not, because you must read the book to understand what effort he has made. Some of the reforms that he has suggested are, reform should not focus only on new substantive law. It should rather focus on speedy implementation of the laws. They make laws after laws, without making what they called an assessment of a new law on the present system of judiciary. There is no impact assessment. The result is the courts are burdened with new laws and they cannot implement whatever laws were there for. Then more of professionalism, says, in justice delivery system and a more common sense approach to the laws. And he has suggested a very good idea to build a centralized knowledge of grid for lawyers and judges, which can be accessed by them so they can be informed and consistent decisions. When I said this, in fact, the present CGI is already talking about certainty of law. There is no certainty of law. There is no certainty of law in the country. And when it comes to Supreme Court, most uncertain. It all depends which bench it goes. One bench will take one view, another bench will take another view, third bench will third view. You never know what will happen to the SLP or the civil appeal. Uncertainty of laws to that extent. So this is a good assessment how it can be brought about. One has to see certainty of law. Then he has said that templated pleadings with the help of AI so that all litigants are placed equally irrespective of the caliber of lawyers. With a lawyer like Mr. Reddy sitting on one side and another lawyer who is not that capable as Mr. Reddy, the other side has got a tough time. He does not have equality before law. So he wants to ensure that all this pleading, everything is, standardized. And you go to the AI, and I find my grandson asked me a question that if we have a judiciary, we have some essay writing. Now, please tell me these. He put some queries to me. How can the judicial system, how can the delays be avoided? How can things change this? Then immediately for me, when I started saying, he was looking at his laptop. Whatever I was saying, it is there already. In the AI has said this has to be done, this has to be done. Positive dispute resolution, speed, everything is provided. So they are all fed down. Then he has suggested, Mr. Prasad has suggested, recording and broadcasting of proceedings. That's very, very important. It's already happening. The Supreme Court proceedings are being, you can watch it. That's a very good sign. Very good sign. And I remember when I was in Supreme Court, this was not there. And some of our judges also were unrestrained. They used to make a comment, any comment. Now it is not possible. I remember while sitting with a particular judge, he made a comment on a very senior lawyer. And the senior said, I will not appear in law in this court. Then I just told the senior lawyer, calm down, calm down, calm down. So judges are also prone to, if you incite them, they'll come out. They'll be provoked, they'll say something. He said, why? We are not granting bail. We said, we are not granting antecedent bail. They said, all right. Then let a direction be given within 6 months. The trial should be over. So my brother judge said, why? Is it because you senior lawyer so-and-so is saying so? The system should be uniform. Why you should have preference? He got irritated. Right. So these comments will not come out. And in any case, you find one comment made by Chief Justice or a judge out in the papers. So transparent. Reactions. Lawyers signing. This statement should not have been given. Another set of lawyers say, no, there is nothing wrong in that statement. You have seen the papers. So therefore, judges should be restrained. They should not express this opinion. Listen, discuss, and pass an order. Transparency will help that. Lawyers should not resort to lying and perjury. Very difficult, very ambitious. Why? Very, very ambitious goal. And should not extract high fees. This is again very ambitious. Yeah. They can charge, this is a good session again, they can charge contingency fees after winning a case and take only a small fee at the beginning. It is quite a sensible thing. Very recently, I found my son, he hardly charged any case fees, and the claim was big, the insurance claim. And when the party succeeded in the Supreme Court, the party said, sir, I have got 13 crores now. I didn't expect this. I'll give you a big chunk. Let ask me what is that big chunk. But it did, right? So this is very successful. He can work very nicely. Then he said, we must follow the American system of consequential damages, penal damages, and award costs to the winning party as per actuals. This will stop the unnecessary claims, you know that. This is a very, very important idea, and there is also a book written by Costs by Arun Mohan, Dr. Arun Mohan. Very nice book. This awarding of costs very important. Then corporate fraudsters, he has named them Nirav Modi and Vijay Mallya. Right.
I can represent you when you get sued.
they should end up becoming poor. There are, he has excluded some also, some more. They are it. Anyway, I am not saying so. Yes, it's there. Whistleblowers should be rewarded and witnesses must be protected. It's very much true. Witnesses should be protected. Whistleblowers should be rewarded. But all these provisions have come in now. Witness protection is coming. Not in. Nothing. Now, courts should be inquisitorial like the European courts, not adversarial like the US and English courts. This will be in alignment with the Indian mindset. Right. This is very important. We find that truth doesn't come out unless if the parties are not pleading anything, you can't go, court cannot go on its own and try to get to the truth. This is what he says. Court should be allowed to go through own. And we find in arbitration also. Sometimes my colleague says, we can give this. I said, the arbitration, he must claim. No? The law is also made like that. He has not made a claim. How will he give it? Right. Now, and then it says, we must discard the concept of sovereign immunity. This is very much correct. To some extent, civil law, sovereign immunity, Supreme Court accepted right. And awarded damages also against the state. And for wrongful prosecution also, there is a provision now. Wrongful prosecution there. Malicious and wrongful prosecution. There are provisions there, but they are not resolved. Some people should dare do it. Then only system will come. But this is a good side. Now, to be deterrent, he says punishment that we impose on the CRPC when I was there. Now the law has changed, some new name given. The punishment should be cumulative. Say three offenses. 5 years for this offense, 5 years for this offense. So he should suffer 15 years. What we do today, the law was concurrent. So the punishment is less. He says more this cumulative effect is given, then it become deterrent, more deterrent. Then police should be prosecuted if they have been found to have used illegal force to investigate. This is very, very important. Police do a lot of things unpunished. This is very, very important session. If police has to be made accountable, this is very, very important. Police is not at all accountable in our country. And then this again, this is a good session. Some restrictions on lawyers have to be removed, such as lawyers cannot have a website. We cannot advise. And lawyers cannot have businessmen as partners. Some restrictions. But I find when I see the WhatsApp and all that, libel law, everything, many of the lawyers are already advertising. You notice that many of particularly youngsters are very much advertising, and those who are very value-based lawyers, conservative type, they don't like advertising. But many of the youngsters, they don't know about those restrictions. They keep on advertising. So these are the sessions he made. And he has written a number of chapters which I have not gone through details, but I can give you the headlines. Chapter 2 is Advancing Courtroom Technology. This I entirely agree with it. One must go through technology, and he has got good experience, having worked in trial legal for quite some time. I was doing a number of international arbitration. I find how they have advanced by technology. Then, revamping India's commercial legal system. Commercial legal system is very slow. In fact, India, there is no commercial legal system at all. When you do arbitration cases, on many of the principles of contract, there is no case law. There is no case law. We rely on commonwealth law, English law, American law, even law they know in Singapore. But India, there's hardly any case law. Right? You find it very difficult. And sometimes there is case law. I was sitting with Justice Jagannath Rao. Yeah, studies a lot. And then he said something in the court in the arbitration, it was a very arbitration. I said, sir, this is contrary to what the Supreme Court has laid down. Which case? Then I showed him the case. He said, we must overrule the Supreme Court. And this happens because the Supreme Court itself judges don't know. And India is a peculiar system. Judges who have never done arbitrations, whether they're sitting in commercial courts or at the Delhi High Court or in the Supreme Court, never done arbitration. They start doing arbitration after retirement from a High Court or the Supreme Court. Then only they come to know what is arbitration. But they set aside our odds. Well, on very good principles, no doubt about it. But experience is also required in the field to be able to judge. Then, fourth, he said, harmonizing Indian law with Indian sense of justice. This is very important. You see the criticism going on Macaulay. In Macaulay, there is no criminal law, no Indian penal, no penal, English penal code there. But Macaulay introduced the Indian penal code here on the basis of English principles of common law. And mind you, झगड़ा तो होता रहता है, फील्ड में झगड़ा होता है. In the agriculture field, two agricultural laborers fight. He accuses something, your wife is so and so. So he says, yeah. Allegation wife. He picks up an axe and gives one blow. The other is dead. Murder ho gaya. She is an Indian, he is maybe a tribal, maybe a Dalit, maybe someone. He is provoked by emotions, kills, and look at the punishment. This is typical English law, influent in India. Then he has also said for constitutional reforms. He is very tall order. Constitutional reforms. For a lawyer to write constitutional reforms. You know what type of constitutional reform now being introduced by Parliament? Something we first have a political consequence. Political consequence, there is no question of constitutional reform. So many constitutional reforms are required. But the constitutional reforms are possible only if, first of all, there is no law with regard to political parties. No constitutional provision. No constitutional provision how political parties will be funded. I am writing all those materials. But I am confident that Decay with the koi sunega nahi. It will be contrary to their interest. Anyway, very ambitious. And then finally said redefining boundaries, fine-tuning of legal principles. I have not gone through it. There may be very good sessions there. I hope people read this book. And I sincerely feel that he should be the Law Commission of India. If some voice. Oh, Law Commission in India also, whatever they recommend, it's not ultimate, it's all political. Thank you very much.
Ladies and gentlemen, it's my pleasure to welcome all of you today to this evening. I'm going to keep it brief because we've already had a fairly detailed and clear explanation to what the book says. In terms of, I'm going to start maybe with a few words about the author and then go into the book itself. Lawyers are very fond of legal maxims and aphorisms. For Anand, also as a professional, one is very apt, which is the thing speaks for itself. As a legal professional, he's had a storied career. First as a founder of as a co-founder of Trilegal, and then as a co-founder of AP Partners, where we continue our journey today. That in itself would be enough of an introduction, but there are some things that get left out, which I would like to focus on, which is the nature of Anand as a legal thinker, and really why is he the right person to be thinking about these issues. There are two hallmarks of Anand as a thinker, which I think are very important here. One is the ability to be relentless in the pursuit of reason and truth. Whenever you're working with him, and there are many in this room who would attest to it, he would really be forceful in trying to get to an answer or an outcome for his client. In this case, the brief that he's holding is different. It's not a company, but it's more the common man. But he brings the same passion that he has for the practice of law to this question. The other is the ability, which I think is somewhat unique and interesting, is the ability to act without necessarily worrying about the sunk costs. It's very easy when you're working or thinking to work with certain assumptions because it makes life easy. Anand has the ability to sort of transcend that and look deeper and question further, which I think makes it very important, especially in this context, which is when you're looking to re-envision what the legal system should really look like. How is it that the common man should experience it? There is a third element, which is, I would suppose, more personal to him, but still very interesting, which is a distaste for the doctrinal and a preference to look at things in a more experiential way. And that brings us to the book. When you're reimagining or thinking about the legal system really, and you think, how does a ordinary person experience it? And then what are the solutions that are needed to make his life better, to make the law work for him? That is really the crux of what this book is about. This very basic and simple question of how do you make the legal system work for the common man takes us down some very interesting and important inquiries. What should be the relationship between the citizen and the state? How do you improve or build on judicial independence? What or how do you hold your officers accountable? How do you make sure that if somebody promises you something, that you can get that person to deliver on his promise? So those are very, very interesting questions that Anand has sort of looked to address in his book. He has made suggestions. You may not agree with all of them, but I think we will all agree that there is a need to ask these questions and have these discussions.
Hello, everyone. As Farah mentioned at the start of this session, Sundays are for quiet reflection. I do hope we go back with a lot of reflection, if not quiet. For everybody for any of us who haven't read the book yet, I'll give a sneak peek, a very small one, with how the book begins. It begins with an illustration. There's a frog, smiling frog in a pot, which is labeled as a legal system. There's somebody saying this legal system feels warm and comforting, while the other person says that's not warmth, my friend. That's the litigation stove slowly boiling you alive. The frog, he says, is like an average Indian citizen. Anand, to begin with, we often talk about legal reforms while in law school. As a journalist, since I've been covering law in courts, how is your book different, and how we as frogs get out of this pot of boiling water? If you could, of course, Justice Patnaik has given us a really good overview of some of very ambitious reforms that you have suggested in the book. But as an author, how is your book different from all the other conversations?
Thanks, Apurva, for the question. So essentially, as most of us in this room and many of us are lawyers here would sort of know as a matter of fact, is that we look at the law on a daily basis when you go to court or when you advise a client. And your experience when you do that, a lot of it is theoretical in basis. Some of it is experience oriented, or what happens in the real world. One of the things that we cross that line when you look at what happens in the real world is to deal with the shocking truth that a lot of what's written in the books may not actually play out. And then you start thinking in ways of what will work best for a client. And that's a daily encounter. We don't piece it together in that particular fashion in our heads. What this book suggests is that while you listen to policymakers and you listen to lawyers, they'll all sort of talk how the law is great and how we do a brilliant job in India and look at all solutions are there in law. Nobody tells you how long and how difficult and how tiresome it is to get there. And that is resulting in a loss of credibility in the legal system. So citizens are finding ways to sort of sidestep the legal system and find solutions outside the legal system. You will find that coming out in various different ways, whether it is using bribery, corruption, violence. There are various ways that people find to get what they believe is just for them. What this book is suggesting is if that keeps increasing in terms of percentage terms, and more of us start beginning to lose confidence in the legal system, it's like that frog that will ultimately boil to death. So unless a whole host of us jump up and start screaming, that slow, gradual increase in lawlessness will cause a collapse of a nation. So that's really why it suggests that we want to do some fix.
Thank you so much, Anand. I'm going to take that forward. And Apurva started with the beginning of the book. Let me go to the right to the end of the book and talk about the reflection. And I want to throw it open to all the panelists, whoever would like to take it. I think Anand talks about a new order that is not defined by fear of authority, but by trust in justice. It's unlocking an India where opportunity is matched with fairness, where power is balanced by accountability, and where the everyday citizen finally stands at the center of nation's legal universe. My question to the panelists here, and anybody could take it up, is that if they could reflect from their journey of pain points or any anecdotes where they feel that the legal justice system of today is not adhering to the ideas that Anand has talked about in his closing remarks, and why some of these are absolutely essential as we're moving forward into an era which is AI and everything around us changing at a pace that we had never thought before. So why should the justice system also feel the need to keep up and keep pace with that?
I'll try and break it up.
Sure.
There's no deficiency. We don't need more laws. We have to implement the ones we have in place. For example, I'll give you an example from the book. Anand recommends that we switch from the common law system to the civil law system. First of all, it will need a constitutional amendment. He recognizes that. It will need a constitutional amendment. I'll be retracing my steps. It's not going to be easy to go down that route, because whenever you change the constitution, and this is going to be changing the basic structure of the constitution, if I may use that expression, it will not happen. He does it because he believes that in an adversarial system which the common law supports, the judge cannot get to the bottom of a case. And I disagree with him. And I'll tell you why directly. Section 165 of the Evidence Act permits a judge, a trial court judge, to question every witness, every party, on every issue, whether it relates to a relevant fact or an irrelevant fact. The judge can question them. The judge can also seek production of all documents that may be there with a witness or with a party before the court. Now, why has this provision not been employed successfully or as widely as it should be? Which takes me to the basic difficulty that exists with our legal system. Our legal system is not prohibitive. We invite litigants to assert their rights by coming to court. We are very peculiarly situated. We have a large population. We have a colonial past, right? And we need our citizens to assert their rights before courts of law. But how have we gone about accomplishing that? Look at the judge population ratio. I know there are a lot of people who say that no, judges have a lot of holidays, therefore it's not the judge population ratio. But the judge population ratio is one of the principal factors. If you don't have a sufficient number of judges, and if you expect high court judges to hear 200 matters a day, you surely cannot expect them to look at all the niceties of all the 200 matters listed before them. So this is one of the issues which I believe that Anand did not address, and I think he deliberately did not address this because there's already a lot of debate on this. And the executive and the judiciary have never agreed on this. Judges will always tell you we need more judges. The executive believes that there are enough judges as it is. They don't want any more. Because if there is any one pillar of state which questions the executive, it is the judiciary. You must bear that in mind. Therefore, the existence of the judiciary is not particularly relished by the executive, because our principal purpose is to restrain the executive from conducting itself in a manner, both commission and omission, to discharge their executive functions. But I am digressing now. The question was something else. The question is that how do we get to that utopian state? I have no path which will definitely lead to that utopian state, but I can tell you this. If we were to implement our laws, and if the docket explosion was manageable, then we would have opportunity for judges. They would have the time to apply themselves to the task at hand, and maybe we would be able to implement all the laws that have been enacted by Parliament without looking for shortcuts, right? So my view is implementation is necessary rather than changes in the law. That's my belief.
A very quick response. And what Justice Mridul says is very true in the sense of there's a shortfall in the number of judges that we have. That shortfall isn't going away in a country of 1.5 billion people. So should we, for the next 100 years, just think in these terms? And which is where a lot of my suggestions actually with regard to this particular aspect goes to technology. Is that how can you use technology to very quickly take off the plates of judges, of human judges, put it in the realm of an algorithm? How can you deal with a whole host of cases that take 4 years, get them done in 4 to 6 weeks? Technology can do it. It's being used in various other parts of the world. No reason why it should not be capable of being used here. It is used. You can today fly aircraft without pilots. Delivering judgments is a lot easier. So absolutely true. Today, they have not been replaced. They can supplement. So if a judge can get a draft judgment out of an algorithm, look at it. If he wants to make changes, and then bless it one way or the other. It'll make his job so much more quicker. He'll be delivering so much faster. You'll also be more consistent because the same algorithm that works through the country. So there are ways that you use technology. We actually, when you work with law firms, a lot of law firms are using technology. If law firms can use technology to deliver consistent, high quality legal advice to clients, there's no reason why the same ideas can't be actually put to the state.
I can't but agree with my brother. But there is a difficulty. If judges were to get draft judgments, we would be prosecuted. First of all, I must point that out. We would be prosecuted. We are required to discharge our functions without being influenced by anybody in any manner. So we can't receive draft judgments. Whether we can use technology to become more efficient, to become more effective, yes, I believe we can. And live streaming of any proceedings, including proceedings in Parliament, with utmost respect to my friend in Parliament, has the effect of sobering down participants. So the minute you introduce live streaming, the judges are more reticent, which judges should be, and lawyers are more circumspect because they are unable then to carry things in appeal and say, I argued this before the High Court. So I am all for technology. But judgment writing, I don't believe we've reached a stage where you can replace judges with artificial intelligence. And I'll tell you why. I'm not very good with technology, but I remember that eventually artificial intelligence does not have emotion. And correct me if I'm wrong. Right? So therefore, an interpretation for the spirit is willing, but the flesh is weak, would be the drink is good, but the meat is bad. So eventually, you can't do away with judges yet. We may reach that stage. And all strength to you, Anand. I hope we get to that stage. But at this stage, it is not possible to replace judges with artificial intelligence.
You said live streaming
Yes, sir.
makes everybody sober. So can happen during judges. But it's the live stream, our experience shows, so far as parliament is concerned, the members have become louder.
So I was just going to say that if I may just come in for a couple of things. That was exactly what I was going to say, sir, that my experience has been live streaming of parliament has made it more theatric. Because now members are trying to have that 30 seconds or 1 minute of their piece, which will be becoming viral. That will be something that they'll be able to circulate on the WhatsApp groups. So it has definitely brought down the moderation of the speeches in the parliament. And sir, I must tell you that I have now witnessed that this has started affecting in the courts also, because some of the matters, maybe not at the Supreme Court level, but in the High Court, where the lawyers know that these matters are going to be viewed by everyone. When the whole state is interested in a particular matter, and I was party to one such matter, there was one lawyer who was just playing to the gallery all the time, speaking in 2 languages so that it reaches the widest audience. While we couldn't get up and protest, we at least requested the judge that, look, we follow the English as a common medium. So let the arguments happen at least in one language so that we are able to follow it better. But on the main question, if I could just come in for a bit, because I have a slightly different view. I mean, I agree with the idea that technology should be used. I agree with Mr. Siddharth's suggestion that we need to have more judges. But having more judges, infrastructure is something that's going to happen in the longer run. I mean, someone will need to work towards it. I'm sure the government is wanting to bring more judges, but I feel we have to make do with what we have at the moment to deal with the crisis which is in present. So Justice Patnaik had mentioned how just with effective management they were able to deal with this caseload in Madhya Pradesh. Sir, I have been witness to one registrar, judicial registrar that we had in the state of Andhra Pradesh when I was a very young lawyer. The registry was in a mess, but this was a very efficient district judge who was posted as a High Court registrar. He just came. He undertook docket management. He went to the judges, explained to them that we can bunch matters like this, we can list matters like this. The pendency in the High Court came down by 25% in 2 years that he was a registrar. He then became a judge of the High Court, unfortunately. Fortunately for him, but unfortunately for the system. And it went back to normalcy. So, sir, my thought is, with the existing systems, there is a way where we may be able to run them a little better. We haven't brought in professional management to courts yet. We don't have any, because it all depends on the Chief Justice. The Chief Justice could be a good manager. He could be a terrible manager. He could be a great judge. The skill sets are very different. For a Chief Justice to run a state in the High Court and for a Chief Justice of India to run the country and administer the justice, it will need great management skills. And I've seen that some of the greatest judges are extremely poor with management skills. And there have been some very mediocre judges who have turned out to be brilliant Chief Justices because they are exceptional in management skills. So I really think the Chief Justice of any court, High Court, in the way our courts are functioning, he should have the assistant, because first, you're picked up because you're going to be a good judge for judging the cases. You're not picked up because you're a good manager. Now, rule of seniority ends up with maybe a brilliant judge becoming the Chief Justice, but he may be an absolutely poor manager. Now, where is the institutional support we have? Where is the collaboration with some business schools or management consultants that come in and provide that support to the Chief Justice, because that is providing support to the High Court at the High Court level and Supreme Court. Now, we don't have that. Now, this is something that could be done even without artificial intelligence coming in and the technology being able to amplify it. So, if we use our existing infrastructure, put in place certain systems. I think Anand in some part has touched upon this docket management. He's also mentioned about an international organization that is willing to lend arms to whoever wants to use that infrastructural ability and institutional ability to build that institution of managing the dockets well. So we may have to get down to this very fast, but the single biggest problem that I find is who has to get down to this. Our judges have been so guarded in protecting the institution, they don't let the executive come in there. They don't let anybody else come in. They're extremely guarded, and they have been complete failures in terms of doing this docket management with what we have. The infrastructure, the number of judges needs to increase, the courtrooms need to increase. So, but I think if something could be done on this to start with and use technology to aid, some small steps could take us a long way.
Court management system were tried in India. When Chief Justice in Madhya Pradesh, I know many places court managers were appointed, but did not work. Because the management people who came, all big management people, they could not understand the court system. They could not, they gave up. I know Mr. Mohan Gopal was there, were trying before time and people, this people, that people. They were appointed court managers throughout the country was appointed. Orissa High Court appointed number of court managers. Then when I inquired, after it had, inquire where the court managers, they are all left, sir. Right? They are found useless. They could not handle it. So, elephant. Unshackle the elephant is very difficult, even beyond the management. Another thing that he mentioned about, you can't allow people to write your judgments from outside. 100% right. One thing that can be done, which I suggested to Justice Kabir when he wrote judgment, why should he write what Mr. Reddy argued, what he argued, what that argued? Let that submission come to place straight away. Right? And so far as judge is concerned, on the issues, just keep on expressing opinions. That way judges work like this. If that is who drafted, what are the submissions? What are the issues? Both sides agree. Place before the judge and he gives on delivered. And that's exactly what I do in arbitration now. I allow others to draft the plaint. I draft the claim, they put a claim on that readings. And then when it comes to point of dispute, after that I start. And it's working.
So that's the purpose of these written submissions, which I think all of us as lawyers hand over to the courts every day. There is yet another issue that must be addressed. It's not as if Indian courts, there is no technology available. And I can tell you this through personal experience. I went to Manipur and we had a fund, huge sums of money for virtual appearances, for online filing. And you'll be amazed to know that Manipur was going through a very difficult period. Lawyers and not even judges could attend court. So what we did was, within a short span of 6 months, we had systems in place where you could file pleadings before a judicial magistrate first class in a strife-torn area from anywhere in the world within 6 months. You could also appear through video conferencing before that judge from anywhere in the world. So it's not as if we lack systems. But the fact is that we are, and I think on this, Justice Patnaik will agree with me, the amount of work that the workload of a judge on a regular basis completely negates whatever technology that you may apply. Short of replacing the judge with artificial intelligence, where we don't know, that may work, that may not work. But the fact is, short of doing that, if you need an individual with a certain amount of caliber and experience to apply themselves to the facts of a case, right, and come to a conclusion, then you must have people keeping in mind the tasks that need to be performed by the end of every working day. Short of that, all of these changes, court management, case management, we've been talking about this for the past 25 years. And I'm sorry to say that despite all our efforts, it doesn't seem to have worked. The reason why we are discussing is because Anand was bold enough to address the elephant in the room. And it is important for all of us to express ourselves freely on the subject of the changes that need to be made in the legal system pronto today. On that issue, I think we are all agreed.
So, as the only economist in the room, perhaps maybe the exception of Seema.
He's a market man.
Yeah. So let me weigh in on a couple of points. I think one, most people in this room will understand the intrinsic worth of justice and the intrinsic problem with not getting justice. Let me bring the economist's perspective to it. Older people in this room will remember what India was like before 1991 and what India has been like after 1991. Younger people, unfortunately, do not have this experience. But let me assure you that the country is a different place. Right? The country is a different place because we have been able to grow. And while our growth has been decent for the last 30 or so years, averaging anywhere between 5 to 7% on average, and that's already brought in a lot of change, we've only been able to achieve that because we started from a very, very low base indeed. We started from being one of the poorest countries in the world to being a slightly less poor country today. We are barely in the ranks of middle income countries. We are about, I think, 130th on per capita income out of 190 odd countries in the world. So there is a long, long way for India to go. A strong enforcement system for contracts forms the very basis of any growth whatsoever. There is no shortage of countries in the world that have grown fast for a few years and just stalled. So the sort of instrumental worth of justice is very, very large indeed. Adam Smith, back when he first wrote The Wealth of Nations, pointed out three things: peace, easy taxes, and the third was a tolerable administration of justice. And I think Anand has made a great point that we do not today in this country have a tolerable administration of justice. And I think you actually missed a beat in your chapter where you're saying India is today 60th in the ease of doing business rankings. If you dig a little deeper into those rankings, there is a contract enforcement sub-ranking in which India is 163rd. Yeah. So that's actually how dangerous this risk is. Sanjeev Sanyal recently said courts are India's biggest vulnerability when it comes to growth. So this is enormously important. When it comes to Anand's prescriptions, I disagree with a number of them, but I do agree with thrust on two very, very important pieces, which I think he and Justice Patnaik called them out. The number one, and I'm an economist, so I tend to think in terms of incentives. The number one is incentives. Whose incentive is it today to get justice done tolerably quickly? Is it in the lawyer's interest? It is not. Is it in the judge's interest? It is not. It is in the interest of both plaintiff and accuser if they are innocent, but not if they are accused, if they are innocent, but not if they are guilty. So there are very, very few actors in the system who are incentivized to make the system work. And to me, that immediately says a system like that is not going to work. And lo and behold, it does not work. And I think Anand is very much on point in saying, can we align the incentives of at least a few stakeholders? Can we reward lawyers on result? Right? Can we make frivolous things cost more? So if you keep pushing costs, can the costs be rewarded to the loser? I think these will finally bring about some more incentives. So I think by far the ones that are most important and most consequential are these shifting of incentives within the system. I think they are critical, and if at all we do try and focus on some of these should be the ones. The other is the one I think that Anand talks about, which is culture. What is the culture in our legal system today? In the absence of incentives, culture is what gives you soft norms and soft incentives. And he rightly points out that the culture in courts is dysfunctional. It comes from 17th century England. I don't know. Before that, I don't know. So, if we cannot change incentives, we must change culture. We are all equal citizens of a country that is aspiring to become great. We cannot have a culture that does not treat us so within a justice system. I'll stop there. Thank you.